Hi, everyone. Thanks for joining us today. My name is Christina Vessels, and I'm here with my colleague, Ashley Allione. We are both attorneys in Venable's nonprofit organizations practice. We're a year and a half into this pandemic, and nonprofits such as yourselves have really done an amazing job pivoting to new fundraising methods to make the most of virtual fundraising efforts and events. But as is always the case when you bring fundraising online, things can get kind of prickly quickly. So over the next hour, we're going to talk about some of the compliance challenges posed by new or new-ish online fundraising efforts and give you some ideas of best practices that your organizations can consider when engaging with corporate supporters in the months ahead. So for those of you watching today's presentation for CLE credit, please stay tuned and we'll make sure to share the CLE code with you later on during the webinar. And as a quick housekeeping question, we'll be monitoring questions as they come in. To the extent your question is, fairly brief, we'll be happy to answer it as we're going through. But some of the longer questions may need to be addressed at the end of the presentation or in follow-up. Don't let that deter you from posing your questions. Just know that if we don't answer during the webinar, we'll answer at the end. So with that, I am going to turn it over to Ashley to tee it up with an overview of the regulatory landscape.
Great. Thank you, Christina. So today we're going to talk about new fundraising methods that nonprofits are availing themselves of, but really boiled down to their most basic form. All these efforts are governed by the same state charitable solicitation laws that we think of in connection with more traditional fundraising. So we're going back to the basics here quickly. There are about 40 US jurisdictions that have charitable solicitation laws, and laws regulate any request, whether it's direct or indirect, for money, property. This can be in-kind donations or other items of value when the request suggests that the donation will support a charitable purpose. And one note here is that a charitable purpose is not limited to a 501c3 charitable organization. It can also include social welfare, advocacy, fraternal, and other types of causes. So really, unless you know that your tax-exempt organization is exempt from these laws, consider that the laws will apply. And importantly, a nonprofit organization should generally be registered to solicit in a state, not only if it wants to fundraise for itself or through volunteers pursuant to its instruction, but a charitable solicitation license is also likely required if a nonprofit wants to engage a third party to fundraise on its behalf. So pertinent to this presentation, if your nonprofit wants to engage with a commercial co-venturer to conduct a charitable sales promotion, if it wants to hire a professional fundraiser, fundraising consultant, or engage in another third party to do fundraising on its behalf, these laws will apply. And in each of these cases, a charitable solicitation license as a prereq to the third party's fundraising efforts. So even if we do look at the handful of states that don't have charitable solicitation laws, those states do have unfair and deceptive practices laws, and the principles in both state solicitation laws and the state UDAP laws are the same. There's a focus on consumer protection. So typically state charitable solicitation laws protect the public by requiring details from nonprofits and third-party fundraisers who fundraise on their behalf, by requiring registrations and periodic disclosures. The registrations provide the public with insights into who runs the organization. So if you filed them, you'd be familiar with these registrations asking for lists of officers and directors, your mission, brief detail on some states ask for financials and other updates, and then periodic reports that provide transparency into fundraising efforts, which will allow the public to see how much was raised, how much was spent or allocated, and some other details. Several states do require that nonprofits disclose whether they retain paid fundraisers in the state, and fundraisers, as noted on this slide, are required to file registration. So they upload copies of contracts with fundraisers, charitable organizations, And then they're going to report the details on each of those engagements. So how much they raised, whether they took a percentage, and generally the net amount that was paid out. And again, as you can see on the slide, it's for consumer protection to show the public how much funds are being raised. But with that said, not all types of third-party fundraisers have registration obligations. So there are cases when a fundraiser falls into sort of a gray area and it's not regulated by the state solicitation law. But even without registration and reporting obligations, people who do fundraise for charitable causes do need to make sure that they're making disclosures that are appropriate to the type of fundraising that they engage in. So all to say that if your fundraising relationship falls outside of the laws, you should still be careful not to mislead the public or hide terms about the effect of the consumer's purchases or actions. So before we dive into some of the newer issues that we're seeing, we're going to lay out the basics on 4 main issues. And these are really, in broad strokes, 4 main ways that third-party entities typically fundraise for charity. So we're going to cover, first, what is cause marketing? Second, who is a commercial co-venturer? Third, who is a professional fundraiser? And fourth, who is a fundraising council? And it's really important to lay the basics here to better understand why some of these newer fundraising methods don't necessarily fit into these categories. So first, what is cause marketing? Cause marketing, it's also called just cause marketing, and it's a catch-all category that typically describes a relationship between a nonprofit and a for-profit company when both organizations stand to benefit, though they have distinct roles in the effort, which are outlined on this slide. So typically, the company is the primary driver behind the collaboration. The company drives a benefit, a halo effect, or other positive marketing, and it's associated with having their brand seen aligned with the mission they're supporting. The nonprofit, by contrast, it has a passive role, or usually has a passive role, in simply licensing its name and marks to the company for the campaign. And one reason for passive involvement is that most charities will try to avoid incurring unrelated business income tax, which can be incurred if the nonprofit advertises on behalf of the company. Different types of cause marketing efforts can include social media campaigns, matching campaigns, statements of general support, or promotion of corporate support that's static. So for example, if a company wants to say, company is proud to support ABC charity, or in 2021, company gave $10,000 to support ABC charity and its mission. In these cases, the donation is not tied to a consumer action. It's a general statement of corporate support. There's also point of sale register campaigns. So I'm sure everyone's familiar with this. When you're at the checkout at a grocery store or the pharmacy, you'll see a little prompt that says, would you like to give $1, $5, or $10 to charity? Roundup campaigns, similarly, I'm sure everyone's familiar with this as well. Would you like to round up to the nearest dollar? And perhaps most famously, charitable sales promotions. So this is tied to a consumer action. For each box of cereal, for example, that you purchase, we will donate $1 to ABC charity. But it's important to note that except for charitable sales promotions that are conducted by commercial co-ventures, most of the examples that I just gave involve volunteer fundraising efforts, and they fall in sort of gray area that they're not expressly regulated under state charitable solicitation laws. But regardless, certain basic principles will apply. So you'll want to make sure that you have the charity's consent to use its name and marks, and that you're being transparent in marketing materials. So the first cause marketing piece we'll talk about is a charitable sales promotion, which is conducted by a commercial co-venture, or a CCV for short. One note that I wanted to make here is that often people refer to the entire promotion as a CCV. So your nonprofit, a company might approach you and say, do you want to do a CCV partnership, or do you have any CCVs? Technically, the promotion is legally referred to as a charitable sales promotion, and the company that's conducting the promotion is the commercial co-venture or the CCV that files a CCV registration. It's just a note because sometimes it gets a little confusing how the terms are used colloquially. So just a note there that a CCV campaign conducted by a CCV, the company, typically involves any advertisement or public representation that the purchase or use of a good or service will benefit a charitable organization, social welfare group, or another nonprofit entity covered by state charitable solicitation laws. This is probably still the most common cause marketing campaign structure. And to be compliant for a campaign conducted nationwide, the parties need a contract that satisfies certain requirements, should file registrations. The states are listed on this slide, CCV registration states, as well as the charity registration states. And if applicable, bonds, those would be applicable to the CCV, and then reports after the campaign ends detailing the results of the campaign. And again, keeping with the transparency theme, the marketing materials for CCV campaigns should make clear the material terms of the campaign. You can see some of the key components here about information that should be included in the disclosure, but really you need to make sure all relevant terms are included. So if there's any discount code, a minimum or a maximum, or if supplies are limited, for example, promotion will be conducted, supplies are limited, or promotions only available to residents of a certain state. Those are key terms to include in marketing disclosures. So the third of four main ways that third parties fundraise for charity is this regulated category of professional fundraisers. They're also known, depending on the state and regulated by the states, as professional solicitors or commercial fundraisers. So again, just a note that the terminology does change depending on the state. But for the most part, a professional fundraiser is a person or entity that receives compensation in exchange for soliciting contributions. It may also include a person that has custody or receives control of any funds raised for charity. And you'll see why this is important later in this presentation. But in the traditional sense, professional fundraisers are people that are paid to call, they're telemarketers, they're people that go to door, they engage in other direct fundraising efforts. So they're making contact with the public and they're asking the public to contribute to a charitable organization. Importantly, they're making the solicitation ask. And a key component to whether a person or entity is classified as a professional fundraiser is that the person is compensated in exchange for soliciting or exchange for collecting the funds. But as it's noted on this slide, most state definitions do exempt bona fide employees from the definition of a professional fundraiser. So for the most part, we're talking about third-party outside fundraisers that your nonprofit would pay or compensate in some other way to fundraise on its behalf. And the classification of a professional fundraiser can also come up in many of the cause marketing efforts that I mentioned earlier. And I did say those are usually volunteer efforts, but there are cases when your nonprofit might want to partner with a company to do a checkout program or a roundup program, and the company may collect funds on behalf of your nonprofit, or it may take a percentage of the funds raised. So if you're thinking about it and a donor is donating $1, then you're going to ask, is the dollar going to charity? Is 97 cents going to charity? Who is collecting the funds? So those are important pieces to think about whether you might be falling into professional fundraiser territory, whether the company might be, and then that will impact other contractual considerations. So companies that want to avoid being classified as a professional fundraiser should not retain any portion of the funds raised. 100% of the funds should be transmitted to charity. And one reason, again, why this is important and to just understand whether the company is classified as a professional fundraiser is because professional fundraisers have fairly onerous registration obligations. This includes state registration, contract requirements. It includes state-specific language that needs to be included in the contract, as well as bond requirements and periodic report requirements. And as noted in the beginning of the presentation, the charity's registration to solicit is an underlying prerequisite to the fundraiser's ability to register. And in addition, in some states, a nonprofit organization could face liability if it works with an unregistered fundraiser. And one way that you could protect your organization to make sure that you're in compliance is to just include in your contract representations and warranties that make the fundraiser represent and warrant that they are in compliance with charitable solicitation laws, including registration and reporting for professional fundraisers where it may be required, depending on where the work's performed. So last but not least, the fourth category that we need to know about before diving into novel variations of third-party fundraising that we're going to talk about today relates to fundraising consultants or fundraising counsel. Again, a different name depending on the state. We can't make it easy, but those are the two primary names that are used. But in a nutshell, for fundraising consultants, think about strategy related to fundraising. These consultants don't actually make requests for contributions. So in comparison to a professional fundraiser makes the solicitation ask and or takes custody of the contributions. And here, a fundraising consultant acts behind the scenes. So it helps the organization behind the scenes with its own fundraising efforts. It may develop marketing materials. It may be a direct mail company. It may be doing a survey to help you understand where you should target high net worth donors. But these are persons or entities, again, that are paid to manage, advise, or plan on raising funds for charity. But your nonprofit is making a solicitation ask. They are not making the solicitation ask. Similar to professional fundraisers, fundraising consultants are regulated under several state charitable solicitation laws. There are contract requirements, again, that require state-specific language. There's also often registration and reporting requirements, but it's typically not as onerous as the requirements for professional fundraisers. There's less bonding requirements, and in some states, less reporting requirements as well. So nowadays, as depicted on the slide, there are new and continuously evolving fundraising methods. You have these methods that we're going to talk about today: online donation platforms, NFTs, esports, and more. And one major challenge with the state charitable solicitation laws and how they characterize professional fundraisers and fundraising consultants in particular is that the laws were drafted before the internet became what it is today. But even if the laws were drafted 10 or even 5 years ago, the fundraising landscape has had an incredible change in the past few years. And it seems like it'd be hard to predict really how people would be fundraising today. We do have the Charleston Principles, which are non-binding guidelines that were approved in 2001, and they provide a framework to understand the reach of state charitable solicitation laws related to online fundraising. But they really, they're non-binding, and they were formally adopted in only 3 states. So they offer definitive counsel really only in a few cases. So therefore, we're left in somewhat of a gray area for many of these fundraising methods that are not squarely addressed under state law. And often this poses a challenge for nonprofits and companies who want to engage in these more novel fundraising relationships, because you're left with a lack of clarity about how to comply with state law. So with that background in mind, Christina is going to talk about how charitable solicitation laws apply to some of these newer fundraising methods, as well as some of the recent developments in state law that are coming to regulate online donation platforms.
All right, thank you, Ashley. We had a few questions come in this first half. We'll give sort of a cursory answer to those, but we may want to kind of follow up. So the first question was, is registration required just for 501c3 that solicits only from its membership? In true lawyer fashion, it depends. That is a state-by-state exemption. Probably most states have exemptions for when organizations solicit only from their membership, but unfortunately requires kind of a more comprehensive view of where your members are. There were a couple questions related to professional fundraisers. One asked how it relates to full-time employees who are dedicated to fundraising. Same answer, unfortunately, most states have exemptions for bona fide employees. And so, assuming that the director of development, for example, is a true employee of your nonprofit organization, in most cases they are exempt, but, it can be helpful to take a look at where they're targeting their fundraising efforts just to double check. And then for a grants consultant, would a grants consultant be considered a professional fundraiser? Probably not. We would need to look, at what other activities or deliverables the grant consultant performs, but generally preparing drafts, advising a nonprofit organization on where to apply for grants and that kind of activity would be more of the management and advice related to fundraising rather than solicitation efforts themselves. So a grant consultant may be regulated as a fundraising counsel, but is probably unlikely to be viewed as a professional fundraiser. All right. So as we transition between sections here, I guess this also seems like a good time to tell those of you who are watching for CLE credit that today's code is originally Fundraising 2021. So again, Fundraising 2021, and we'll repeat it once more at the end of the presentation. So with that, as Ashley said, the question becomes, what do you do with a company that isn't, strictly speaking, in the business of fundraising? Even if their overall business model seems to have been designed or otherwise evolved around encouraging charitable giving in significant respects. It's a cliche, but it depends, right? There are too many permutations on this to give a single, definite, universally applicable answer. But there are some guiding principles that you can look to and follow when you're crafting the deal terms of your agreements with companies to ensure that you are compliant with law, or at least that any risks presented with your collaboration efforts are low. So online donations really have grown exponentially and moved beyond the simple, donation buttons that charities had on their website. And that was, the impetus behind drafting of the Charleston Principles. But now we have companies whose business isn't that of a traditional fundraiser. They're not going out and asking for donations in the way you might think of, or frankly, in the way that state's charitable solicitation laws originally thought of. Nevertheless, their overall business model is so intertwined with charitable fundraising that we really have to consider the rules. So, for example, you might have a company who advertises that donations to a charity made through the company's website may be used as entering a promotion for a chance to win, a sweepstakes. You might also have companies that facilitate person-to-person or peer-to-peer fundraising campaigns, such as those conducted through social media platforms. And there are even really, evergreen campaigns that companies have really interwoven into the fabric of their corporate mission and their brand. And they offer sort of ongoing opportunities to round up the value of your transaction with those companies in order to donate the change to charity. Often, but not always, the actual recipient of donations raised through these online platforms is a single charity who partnered with the company for purposes of receiving the contributions made through the website. This, charity partner often uses donor advised funds, or DAFs, to receive and distribute donations to the charity actually named as the beneficiary on the website. It's this last detail, right, that, the way that the platform contracts with the partner charity that may use DAFs to grant funds to named beneficiaries, it's that detail that's a direct response to the challenges posed by states' existing charitable solicitation laws. So what do I mean by that? Well, the laws regulating professional fundraisers almost always require the fundraiser to file notices and reports for each contract entered into for fundraising services with or for a charity. Traditional fundraisers didn't contract with that many charities at one time. Before the advent of the internet, the kind of workload that would have been involved for, working simultaneously for 10 or more charities would have really been impossible to sustain. But now a platform might be paid a fee in exchange for fundraising efforts conducted through their platform on behalf of hundreds or even thousands of charities. And if state laws were to be followed strictly and literally, this would mean registering and reporting as a professional fundraiser for those hundreds or thousands of charities. Because the size and the scale applied to, that the current regime, the current compliance regime would be basically untenable for these new fundraising platforms, we've seen a rise in partner charity and DAF models where the company or platform contracts with a single charity partner and reports on a large scale their activities with just that one charity. That leaves it to the charity who operates the DAF to exercise their variance power or that, exercise discretion and control over granting of the funds raised through the platform and recommending, using the initial donor's recommendation to transmit funds to the named charity on the website. I guess as a quick aside, I realize many of you listening today are representing your own established charitable organizations. You may already be registered nationwide and think that this model may not be applicable to you, but because it kind of goes to the obligations of the company or the platform fundraiser, oftentimes even major charities are still using this sort of three-party model because it sort of simplifies the obligations on the platform to comply. So the platform fundraiser / DAF model isn't necessarily a problem, but because it doesn't fit neatly into states' charitable solicitation frameworks, it's ripe for being handled differently by those engaging in these activities. And in some ways, this lack of uniformity or lack of a uniform standard is what can cause situations where the public may not be provided with all of the material information that they need to make an informed donation choice, or at least they may not be provided with all the information that state regulators view as material. Without, a clear uniform standard to apply, what we have instead is basically, an amalgamation of places where companies who conduct these types of online efforts and the charities with whom they partner can look to see, okay, what would or maybe should be considered a best practice in this space. In general, the starting point for any of these analyses should really be, as we said, consumer protection laws and charitable solicitation laws. Always start with, the material terms. Are they clear to the donor before they make a contribution? Would a reasonable person understand that, for example, a DAF may exercise variance power over funds contributed? Maybe not. And so, the general consensus now seems to be that, that point at least is a material term that needs to be disclosed. Beyond general consumer protection and obviously, founding principles in states' charitable solicitation laws, you might also look to new legislation being enacted or considered by states. You would look to recent enforcement actions or settlements with state regulators, and even, state and federal guidance that's been published online. All of these really are out there to help really to help donors make informed choices and informed decisions about where to contribute, but also to protect the charitable organizations that benefit from fundraising efforts conducted by third parties on these platforms. So there's obviously even right here on this slide, there's too much really to go into the specifics of all of these, but I guess we'll start with California's Assembly Bill 488. California's legislature passed Assembly Bill 488 in early September, and the measure is expected to become law really any day now because it was enrolled and presented to the governor a few weeks ago. Even though the operative provisions of the law won't take effect until January 1st of 2023, I think this is really a great example of a state acting to fill a gap in the law presented by the realities of how companies and charities are working together to fundraise and support their missions on a much broader scale. So now, basically, instead of trying to shoehorn in compliance obligations into the buckets for commercial fundraisers or commercial co-venturers or fundraising counsel, if those categories didn't really neatly apply to the conduct issue, at least in California, non-traditional fundraising companies now also have a new category to consider. The law basically recognizes now charitable fundraising platforms, platform charities, and beneficiary charitable organizations. A charitable fundraising platform is really what we've been talking about, right? It's any entity that uses the internet to provide a website or a service to persons in the state, which facilitates fundraising. We won't read through all of the examples, but the state is clearly trying to bring under their umbrella, peer-to-peer fundraising efforts or other activity where, or other online websites where activity on those websites triggers donations. So, think of GoFundMe charity or Facebook fundraising, Tiltify, Soft Giving. Those are the kinds of entities that are most likely going to be swept into California's new law once it goes into effect. And importantly, as I mentioned, the law sort of recognizes formally now the role of the two different charities involved in online platforms. They don't both need to be there in all of in every case, but a platform charity is one that facilitates fundraising on a platform, and the beneficiary is obviously the entity that is listed or referenced by name, and that's the entity to whom donors think or are recommending donations to. The amended act, I think, is really in most ways going to be sort of, a typical amendment to fundraising obligations, right? There will be registration and reporting requirements and penalties for non-compliance. The registration requirements will hopefully be a bit simpler than those for professional fundraisers. But there's also a few noteworthy obligations that are new, and when codified, I think will be sort of first of their kind. The platform or the platform charity, depending on the scenario, will now have an obligation to verify the charitable organization's, good standing. So making sure that the platform lists only organizations that haven't been automatically revoked by the IRS and the like. In most cases, they'll still need to obtain written consent to list the charity on the platform. But, there are going to be exceptions to that, which is going to facilitate, obviously, having greater numbers of charities listed. And finally, there'll be a necessity to create separate accounts and then promptly transmit contributions from those separate accounts to the charitable beneficiaries. While there are a few other affirmative obligations that would need to be followed, I think the disclosures are probably the most important. So the state has said that platforms will need to make disclosures that are conspicuous in order to prevent a likelihood of donor deception, confusion, or misunderstanding. And these need to be provided as we kind of saw earlier, before a donor can complete a donation. Among other details, I think the most relevant here are that the platform should disclose the identity of, where the charitable organization that will receive donations immediately from the platform. Is that going to be a platform charity? Will it be, a recipient organization directly? We need to lay that out now. There will also need to be, explanations of how donor advised funds and their variance power might work, and what might be the situations that could cause a donor advised fund to redirect a contribution made on the platform to a different charitable organization. All of these really, all go towards helping the donors make informed donation decisions. So although the California law is only going to apply in that state once it's enacted, or if it's enacted, we do know that there's an appetite for similar oversight of platforms in other states. For example, in early 2020, an assurance of voluntary compliance was entered into between PayPal Charitable Giving Fund and a multi-state group of regulators from 23 states. The Giving Fund was comprised of a charity that received charitable contributions from individuals and then made grants to charities selected by those individuals. This is a type of model which, according to California law, or the California law that we just reviewed, seems like it'll soon be regulated as a charitable platform in that state. But at the outset, the Giving Fund listed only charities that had affirmatively registered with the organization, created PayPal accounts, and passed the Giving Fund's vetting process. Starting a few years in, though, the rules changed, and charities who, simply by virtue of being listed on GuideStar, were now included on the PayPal Charitable Giving Fund's website, even though they didn't affirmatively provide their consent to be there. It's this last point, this last detail, that's what prompted state agencies, I believe, from those jurisdictions to investigate the practices of the platform. Among the concerns that state regulators had was that a donation made by a donor through the Giving Fund was not necessarily intended for the ultimate beneficiary, and this, in their view, wasn't clear to donors. The Giving Fund didn't have a relationship or consent from all of the charities to use their name in fundraising efforts. And again, kind of going back to the variance power issue, donors didn't know that A, this was an option, and B, under what circumstances the variance power would be exercised by the Giving Fund. Finally, I think another big issue was that donors' contact information wasn't passed on to the intended charity if that selected charity was deemed ineligible to receive the donation made by the donor on the platform. So to avoid litigation on the matter, the parties agreed to a settlement that established disclosure rules for the Giving Fund to follow in its future efforts. There were also, some general terms, but it's really the disclosures that I think are particularly insightful for online platform activities. The points basically that are enumerated here are questions that charities, I think, can and should ask before entering into agreements with platforms for future fundraising or broad-based fundraising activities. But I think the short recap here is that, as you can see from this list, there's actually a lot of similarity with the disclosure rules that California included in AB 488. For example, both AB 488 and the Giving Fund settlement terms require unavoidable and prominent disclosures about the party to whom donations are made, whether fees will be charged, the circumstances under which the platform or the platform charity may exercise variance power, and even really how long it'll take for donations to get to the charity. I think, state regulators are really honing in, I think, on what is going to, I think, be soon seen as a definitive list that these platforms will need to include on their website. That's speculation at this point, but you can start to see a lot of parallels, and there's something to be said for that. Interestingly, for point 6 here, the description regarding circumstances of reassignment needs to be, quote, directly accessible from a link within the disclosures. So to be directly accessible means that there's a clear link that you can click on to find, additional information. What then does it mean for the earlier prongs where it says that the disclosures need to be unavoidable and prominent? The multi-state clearly laid out that at least 4 disclosures need to be unavoidable and prominent. And this means that the information is not included in an optional pop-up window or in a linked to page. It means that the information needs to be right there, and it needs to be right there, accessible to every donor before they donate. So, the term of art here is immediately proximate to a necessary field or button used by each and every donor. And what does that really look like? This is a clip from PayPal Charitable Giving Fund's website now. You see, the name charitable organization, Women for Afghan Women, and the disclosures on the right-hand side are satisfactory of the unavoidable and prominent test. I had to get to this page, for example, to click in and enter how much I'd like to donate. And I am forced to see these. Whether or not I read them is always a different question. But before I can enter my credit card information or go any further with effectuating this donation, I at least see how the platform works. So, whether this becomes industry standard or simply, industry best practice, I think that remains to be seen, especially as states consider their charitable solicitation laws and bringing them, up to current with new realities, but certainly a helpful thing to keep in mind. So charitable fundraising that takes place on or through fundraising platforms is probably the most common form of novel fundraising that nonprofit organizations consider these days. Novel, at least, I guess, in connection with how they're considered under charitable solicitation laws. But NFTs are another up-and-coming form of cause marketing. So we'll look at NFTs quickly and then esports before we wrap up in the next 15 minutes or so. An NFT, or a non-fungible token, is proof of ownership of a unique digital asset that is made possible because the purchase and sale happens through a blockchain. A blockchain, which is essentially a network of computers, records transactions in a public digital way. And this ensures that whoever owns the address to the NFT is its true owner. I will confess, NFTs and the actual sort of mechanics of them are beyond me. So we have our colleagues in the payment processing practice did an amazing webinar on this, which is linked to here, and feel free to peruse it at your option. But I digress. So in this pandemic, there have been a few moments to myself where I've said to myself, I love this, right? Like, the pandemic hasn't been great, but there are a few things that just made me laugh out loud and think, well, at least we all have a sense of humor about this. One of those was when I learned about this cause marketing campaign from German. They referred to it as an NFTP, right? Nice little play on toilet paper there. But this was a graphic art sale benefiting Direct Relief. We've seen a few auctions at this point involving NFTs whose sale benefits a charitable organization. And by and large, the compliance considerations are the same. I think first, we need to, confirm with the company how the NFT sale is going to be advertised, and whether, the parties should be looking at compliance with the auction laws or whether the CCV laws would apply to this particular sale. In a handful of states, the charitable sales promotion definition is really very broad, and ostensibly it could cover sales of products, maybe like an NFT, that are not in the sponsor's line of business, traditionally at least, right? So Charmin may be in the business of selling toilet paper or TP, but they aren't necessarily in the business of auctioning off NFTs. When in doubt, compliance with charitable sales promotion rules is a very safe way to proceed. Next, you want to make sure there's an agreement in place between the company selling the NFT and, what are the terms or other circumstances surrounding the NFTs that will be offered for sale. Are there minimum sale prices? Are there minimum guaranteed donations from the company? Will any fees be deducted? Noting that if so, that could actually trigger some professional fundraiser considerations, or at least, you'd want to knock out those considerations from your sort of compliance checklist. Finally, again, transparency. We want to make sure that the disclosures from the campaign adequately inform the public of all material terms of the campaign. Usually this means, it's pretty safe to follow the CCV disclosure rules, but take a holistic view and, what isn't readily apparent to the public as part of this campaign? What would be important for them to know or to understand before they elect to bid on or buy the NFT? Again, when in doubt, you can kind of always fall back on the charitable sales promotion rules. Switching gears to our last topic, we have esports. What are they and why should they matter? Esports involve essentially video game competitions in tournament format. Esports are played at the scholastic level. They're played at, at the amateur level in tournaments, but the most visible esports are being played in professional tournaments. And these professional tournaments can take place in large scale in-person events. At least that's how they were being handled before the pandemic, or they can happen through online live streaming platforms like Twitch or Tournament or GameFly. However the esports are played, whether virtually or live, professional gamers often pay, or rather their sponsors pay, to enter competitions where top dollar prizes are offered. So apart from sponsorships, pros can actually make money from advertising income, subscriptions to their channels, and even direct contributions from their followers. And some of these pros really, they have millions of followers and are bringing in really big money, either because their level of play is so captivating to their audience, or frankly, people just like listening to them, and they've developed these sort of cult following or cult personalities that people just like watching. And so given the size and really their prevalence, their growing prevalence, we need to think, on the compliance front, what are the issues? And to be frank, they can be kind of thorny. Most commonly, esports raise gambling and lottery, consumer protection, and charitable solicitation issues, but they can also trigger sort of more one-off considerations, right? Like ranging from IP transactions and licensing issues, immigration issues, right? Can a foreign esports player obtain a P1 visa for a quote athletic competition? Is an esports competition, an athletic competition, sufficient to get that visa? There can be tax issues. So there really are a host of issues that need to be vetted for any esports collaboration with a charitable organization. But generally, when reviewing a charitable promotion involving esports, the first step really is dealing with lottery and gaming issues. So maybe that's a 1A and a 1B. This is because the basic rule is that a lottery involves offering a prize on the basis of chance for which a participant offers consideration for the chance to enter. lotteries are generally illegal unless they're conducted by the state, they're authorized as a raffle. So more often than not, to comply with lottery laws, we usually knock out the element of consideration and making something a sweepstakes, right? So there's a free alternative method of entering. Here, though, with esports, that's not really the case. We're actually knocking out the element of chance, because with esports, what we really have are contests. Esports are viewed as games of skill. Winners are determined on the basis of quantifiable judging elements. And so, the prizes aren't awarded randomly. Winners are determined by who scores the most points in the FIFA World Cup, or other kind of quantitative metrics that are relevant to the particular video game at issue. States are making, significant legislative pushes to recognize esports as skills-based contests. Maryland, for example, codified esports competitions into their lottery law a few years ago. But even if a esports is not formally recognized by a state's law, when you're collaborating with an esports company, it's helpful to tick off the contest requirements. We're getting a little tight on time here. So I think, suffice to say that, keep in mind, there can be other, compliance considerations when dealing with contests, right? Like, you sometimes are prohibited from charging money for a contest. There can be additional disclosure requirements. Just keep in mind that, there may be other issues to consider on the lottery front. 1B, as I said, is gambling law compliance. So less often implicated, but just as important in reviewing an esports proposal is making sure that there aren't gambling law issues. Again, we're kind of bumping up on time. So in overly simple terms, we need to be careful that participants aren't placing wagers, on the outcome of a sporting event. So if that kind of detail finds its way into your charitable fundraising proposal, a little antenna should go off, and we should kind of investigate that point. So that kind of gives an overview of, what are esports and generally how are they regulated? But how does this morph into an issue that nonprofits are dealing with? This is the second point, right? We've seen permutations on these that raise different considerations under charitable solicitation laws. For example, you might have an esports tournament sponsor that advertises that they'll donate a portion of ticket fees to a nonprofit. Okay, that's a charitable sales promotion, and we know how CCV compliance generally works. Ashley gave us, an overview of that. Great. Well, what about, a gaming platform that advertises that for every new user who registers or completes a free registration, the company will donate? Or what about, a platform that allows users to add on a donation at checkout when buying an entry into the tournament? Again, we've seen these issues before, right? That you've got a free action campaign and a customer donation or register campaign, respectively. These are, fairly routine. We've seen these before, and I'm sure your nonprofit organizations have systems in place to ensure compliance with these types of fundraising campaigns. But what about a scenario where an esports professional or personality makes an appeal to the followers, saying something like, hey, over the next 2 hours, I want to raise $300,000 for XYZ charity, donate through my page? What if we zhuzh it up a little bit and they say that the first 10 people to give $500 or more will get an autographed headset? Just like that, basically, the ears of pretty much every charity regulator and state AG have perked up. And that's really where we are now. We could spend an entire hour talking about basically the nuances of those last couple permutations, but let's boil it down to the key takeaways and what you should think about. First and foremost, where does the money go once the donor hits pay or submits their contribution? Does it go first to the gamer, and then the gamer transmits or reroutes that money to the charity? Or has the gamer installed a widget that allows people to donate directly to your organization's account? It's a lot less risky and a lot easier from a compliance standpoint if we go with that latter option. If donations are directed or routed directly to your charity account. Think about, is the gamer going to take a percentage of funds raised, or will 100% of the funds go to your organization? If the influencer takes a percentage of funds raised for themselves, you very well may have professional fundraiser considerations to think about, and different compliance obligations associated with that status. What happens with donors' information? What if a donor gives $250 or more? How is your charity going to get the name, amount, and contact information of the donor, so that you can send a contemporaneous written acknowledgement? Hopefully you have, an agreement in place in advance of the gamer's efforts. But, if not, the public doesn't necessarily know that there isn't this agreement. So you could get a bit of, blowback if, donors aren't thanked by your organization. So it's kind of good to have a handle on who's doing this for you, and really have, an established set of rules of who will do what. Finally, if you're lucky enough to be dealing with a situation where you do have an agreement and a gamer, you should include reps and warranties about complying with the FTC's guide to endorsements and testimonials. This is especially important if they're going to be working, as a volunteer ambassador for you, or if there are going to be any sort of material connections between the gamer and your charity organization. With that said, though, we know that gamers are acting live and things can get a little haywire when on live TV or live broadcasts. So it's also good to have, indemnity and insurance provisions that will protect your charitable organization in the event that, the gamer doesn't quite comply with the FTC's disclosure rules or any charitable fundraising disclosure rules while they're doing their broadcast. So with that, we've covered a primer on CCVs, online platforms, novel fundraising, connected to NFTs and esports. I know we are at the end of our hour, so, we'll leave you here with, 5 key points to think about when you are working with your online platforms and third-party fundraisers. First, confirm the payment structure and determine, what is the status of this third party? Are they going to be a CCV, a professional fundraiser? Are they simply a volunteer? Or might they fit into, at least in California, starting maybe next year if this law is enacted, the regulated bucket for online platforms? Second, depending on what the answer to that first question is, what are the regulatory compliance considerations that both the company and the charity need to think about? Are there registration, reporting, or bonding requirements? If so, figure out who's going to handle those and do them. Have a contract in place that authorizes you, or rather authorizes the platform to use your name, or otherwise give your consent to how your name will be used on their site. Make sure your disclosures are appropriate for the type of campaign you're conducting. And frankly, that may mean looking to a whole host of sources for some of these online platform activities, right? I think we'll start to see, parties coalesce around what are viewed as sort of the status quo or the standard. But until then, there are resources that your organizations can look to see what might be most important or most critical to include for a particular campaign. And then finally, don't forget, social media influencers, gamers, are they being paid? Do they have FTC compliance or FTC disclosure obligations and the like? That last point can be easy to overlook, but it can be just as important and, a significant source of exposure. So I realized there were quite a few questions that came in on the back half. We will do our best to write to each of you individually to get answers to you. But Ashley and I can both be reached by email, and we are happy to answer questions if you don't get an answer from us as to your particular question presented during this presentation. So I hope that this last hour has been helpful for you all. And with that, I hope everybody has a great rest of their Tuesday. Thank you for tuning in.